Good evening, everyone. Welcome to the third and final instalment of our summer series of webinars from 42 BR Barristers Employment Group. I'm Safia Tharoo, joined by Jason Braier, and today we'll be discussing the really interesting topic of memory in employment tribunal claims. Now, we've had lots of interest in this webinar, and we're really grateful to all of you for joining. So we're just going to give everyone a minute to join the link. Whilst we're waiting, I just want to remind you that all the recordings of the seminars from this series and indeed from all our previous series are available on our website and on our YouTube channel. So please do go and check those out if you've missed any. Last month, we had a really interesting session on injury to feelings awards with Michael Salter and Amrit Palbachi. And if you did miss that, I highly recommend you go back and watch it. In the same vein, the recording of today's session will also be on the website and on YouTube shortly. Now, after today's session, we will be pausing our series for summer, but we do have a packed lineup for the autumn season, and we'll be releasing the dates and the topics very soon, so please do keep an eye out for those. Also in September, we have our 42 BR annual employment lecture. This year, Jason will be chairing a really interesting session on activism in the workplace on the 25th of September. We've got some great speakers lined up for that. So if you haven't registered as yet, then I highly recommend that you do so. The details of that are on our website. Now, for those of you watching live, if you do have any questions, I'm sure you're very familiar with the Q&A box. Please do pop any questions that you have in that box, and we will try and answer them at the end of the session if we have time. If we don't worry, we will follow up by email. And for those of you who did register for today, you will be sent after this session an email which contains the links to the sources that we're going to be referring to. We've also put them into the chat box, and we will be in a moment. So you will be able to click on those if you want to have a look at them as we're speaking. But you can also do that from the email that we send you afterwards. The email will also contain the link to the recording if you want to go back and revisit anything. And there'll also be a feedback form that we will send out too. So please do take a moment if you can to let us know any comments that you have of whatever kind. Now, finally, before we actually start, I do, of course, need to make the usual disclaimer. This webinar should not be taken as any form of legal advice. If you do have a case where you want to discuss any of the principles that we're talking about today, then please do get in touch with Jason or I, or indeed any of the other excellent barristers in chambers, and we will no doubt be pleased to help. So, on that note, Jason, what do we have in store for today?
Thanks very much. Well, today we're going to be talking about, what we're going to be talking memory. Yeah,
I'm glad
right.
You remembered.
Thank you very much. Yeah, sorry, I had to get that joke out of the way at the start of the session. I'm sure it will come back a couple of times during it. It will be as bad each time. So we're going to be talking about memory. We're going to be talking about how memory works and why that is so important in employment tribunal claims. Now, there's been some recent extrajudicial commentary on memory and on the impact that it has on the quality of both oral and written evidence. And it's making some waves in the civil courts, but hasn't actually been mentioned yet in any employment tribunal judgment, let alone in the EAT. And we're hoping, to put that right by raising its profile in today's webinar, because it's an area of such importance to employment claims, to their determination, and it could be the difference between a judge finding in your client's favour or finding against them. And obviously with employment tribunals, so much of what occurs in the workplace is oral, and it relies heavily on people's recollections of conversations or meetings, and sometimes long after the event, especially with the delays that we're getting at the moment in tribunals. And every day tribunals are making findings of fact about whose account or recollection of a set of historic events is more accurate and who should be preferred. And they're doing so in the vast majority of cases without any real understanding or real assessment about how the science of memory actually works. So, is a person who says under oath that they can clearly recall the conversation that's the subject of the proceedings, more reliable than the person who says they remember some aspects, but they're hazy on other aspects of it? Or can the note made by an honest and conscientious manager soon after or the day after a one-to-one meeting with the direct report be relied upon by the tribunal panel as an entirely accurate record of the full conversation that occurred? And what we're looking to do is to look at how the science of memory has been analysed from a litigation perspective, and then to look at what that might mean for us as employment practitioners. Now, do you want to give a bit of the background?
Yes. So probably a good place to start then is the judgment in a case of Gestmin and Credit Suisse. There should be a link in the chat box for anyone who wants to have a look at it. We don't need to go into all the detail of the facts, but in very simple terms, essentially, this was a case about whether or not Credit Suisse had either misrepresented or failed to explain properly to Gestmin the risk of investing in a company which had then invested in the subprime mortgage market, which, for those of us who remember that time, wasn't exactly a good idea. So the question, of course, was, had there been any discussion about these risks? And by the time the issue came to trial, witnesses were having to recollect things that had been said 8 years previously, which sometimes happens in employment tribunal cases as well. So that case was heard by Mr. Justice Leggett, as he then was, and he made some really interesting observations about witness recollection. And what he thought was that courts had actually failed really to absorb and understand what he described as the lessons of a century of psychological research into the nature of memory and the unreliability of eyewitness testimony. And what he said was that he thought this stemmed from two beliefs that were mistaken that many of us hold. First of all, he said, well, we have this belief that says that the stronger or more vivid our experience of recollection of a memory is, the more likely that is to be accurate. And he also said that the more confident somebody is about their recollection, the more likely they are to be accurate. And what he believed was that these mistakes stemmed from a more general misconception, which is that something happens and you make a fixed record of it. And then that record slowly over time will fade. Now, as I say that, I recall the number of times I've made that argument in employment tribunals, and many of us have, particularly when we're arguing about time limit issues, where we'll say, well, look, the more out of time a claim is, the more prejudice there is to the respondent in having to actually respond to it, because how can they be expected to remember something from X number of years ago? But, Jason, what did Mr. Justice Leggett have to say about that?
I mean, the key point that he sought to make was that's not how memory works. And that memories are fluid and they're malleable, and that whenever you retrieve a memory of an event, what you're doing is you're rewriting the memory. And when you're rewriting the memory, you're doing so influenced by a whole array of external features that can manipulate the recollection of the memory. So when we're looking at the context of the litigation process, the external features that influence recollection would include things such as the witness's stake in the litigation. Are they a party to the claim? Do they have a particular tie to the claim, such as being a senior employee giving evidence for their employer? Do they have a stake in that side's version of events? And even if they're not so heavily invested as that, so maybe they're an ex-employee or within our context, so they're not so heavily invested in the outcome for the side that they're giving evidence for, there's still a more subtle influence that's created by the process of giving evidence for a particular side of the dispute. And Mr. Justice Leggett referred to this as the desire to assist, or at least not to prejudice the party who's called the person as their witness, and indeed the party that you're spending all your time in the waiting room with.
Absolutely.
Exactly. And he also spoke of what he called the natural desire to give a good impression in a public forum, which I read in a couple of ways. It's not merely about giving a good impression to your own side in respect of presenting a consistent factual position, but also a good impression of yourself as someone who, at the time of the events that are being discussed, would have done the right thing. You can't imagine yourself as someone that made the mistake. And he noted how greatly the litigation process influences an individual witness. So you've got a witness who's asked to make a statement, and that's drafted, generally speaking, by a lawyer. And as we all know, we're keen to put forward a case where the issues are presented in the client's favour, and we take instructions with that aim in mind. And then the statements made after refreshing the witness's memory from documents, which will often include the statement of case and other documents that the individual witness didn't see at the time that the event happened, because they're all things that are, have been put together after the event. We then ask them to reread their statements and to review the documents again before they give evidence in court. I'm not sure that many of those that I asked to do so actually do so. Certainly some of them don't, however much I make the plea that, that's part of the process. And it all establishes in the witness's mind what they've recorded in their statement. And it causes their memories, or it can cause their memory, to be based increasingly on this, irrespective of the factual accuracy of what is written down.
Gosh.
And he also observes, just from a practitioner's perspective, and I think it's something that he had observed in commercial trials, that it's misguided for counsel to ask a witness whether they understand the difference between recollecting events as against reconstructing them, which sounds like a clever cross-examination question, because all remembering of distant events involves reconstruction. And that is a largely unconscious process in which the strength or the apparent authenticity of someone's memory about a distant event isn't a reliable indicator of the truth of that memory. So what was Mr. Justice Leggatt's solution? Well, he considered the best approach was to, and I'm going to quote from this, place little, if any, reliance at all on witnesses' recollections of what was said in meetings and conversations, and to base factual findings on inferences drawn from the documentary evidence and known or probable facts.
But that's easier said than done, of course, given that we've already identified that in the employment context, so little of that is often reduced to writing.
Yeah, no, absolutely. I mean, you do get things in writing, you get minutes of meetings, you get email accounts of what people think they've discussed, and you get email chains referring to contemporaneous events, which nobody at the time expects are going to be subjected to close scrutiny under cross-examination. So in that case, Mr. Justice Leggatt's solution was pretty much to give those written accounts primacy and to ignore the individual's evidence of their recollection of events. So this is Gestmin, and it's a 2013 case.
Yeah.
It has been quoted 172 times in the Employment Tribunal. I checked again this morning on that. And there have been two fleeting references in the AT.
Okay.
One in 2017 and one in, I think by Corona Judge Edie at the time, I think, and one in 2018 by Mr. Justice Chowdhury. And that is it. But science and the understanding of memory has now moved on since Gestmin, and the tribunal's understanding hasn't yet followed, so far as we can find, having searched for it. And that's where we hope to come in with this talk to change that landscape. Well,
so a decade and a day after Gestmin, we had a really interesting speech by Lord Justice Popperwell. He gave the speech to the Commercial Bar Association, but actually what he was talking about is applicable just as much in the employment context as it is in the commercial context. His speech was called Judging Truth from Memory, the Science. Again, we put a link to it in the chat box and we'll send it out in the email afterwards as well. But what's really interesting about this talk is that he was looking at how things have changed since Gestmin. And what he did was bill his speech as saying it provided tools for advocates in seeking to persuade fact finders how to choose between conflicting oral evidence. Now, I think it lives up to that hype, and we're hoping to explain why today. But his starting point was that the overwhelming majority of witnesses in any type of case, give honest evidence, but that doesn't necessarily mean that it's sound. But that's not because they're in any way trying to deceive. It's often because they have a genuine recollection of something that didn't occur or didn't quite occur in the way that they remember it. And his view was that recollection has perhaps become undervalued, given that there is this increasing primacy, I should say, from Gestmin on contemporaneous documents and inherent probabilities. But what he noted, which is a really interesting point as well, is that in litigation, commercial litigation in his context, but just as importantly in employment litigation, actually, we need to look at not just what happened, but the why. So inquiring into the witness's state of mind. And that's an essential ingredient in so many different types of employment cases. So if we just take a few examples, if we look at a discrimination case, for example, the question the tribunal has to answer is, was a particular act done because of the person's protected characteristic? Equally, in a whistleblowing case, was a particular act done because the individual had made a protected disclosure? And even as something as basic as an ordinary unfair dismissal case, as we know, a key part of the virtual test is to look at, did the dismissing officer believe that the person had committed the alleged misconduct? And so what he was concerned with was the fact that tribunals or courts were conducting their fact-finding, and they had to look at not just the what, but also the why. And his view was that the fallibility of memory, in particular, is problematic when it comes to looking at a witness's knowledge or intention or belief at the time that they did a particular thing. Now, what's most important, I think, about this speech is that whilst he doesn't entirely abandon Gestmin principles, he does effectively pull the rug from under the approach that says, well, don't worry about what the witness says so much, let's concentrate on what the contemporaneous documents say and what's inherently probable in that situation. And he then tries to explain that by looking at the science of memory. And he noted that there had been this surge in scientific research in this past decade, so since Gestmin, into this principle of false memory or recollection of events. And he wanted to try and explain what that meant in practice in litigation proceedings. So at this point, Jason, I feel like we need to don some lab coats and try and explain in as simple terms as we can how memory works. Because once we understand that, we can then understand what that means for the litigation process. So over to you at this point.
Yeah, thanks very much. I kind of feel that I should have an image of a pulsating brain floating in front of me for this part, or that we should be, I don't know, for older viewers, we should be wearing our like Open University lecturer tweeds and brown tie and that sort of thing. But anyway, the first part is the simplest. Our memory is split into long-term memory and short-term memory. And within those two categories, there are three systems of memory which are of importance to the question of how people hold their memories about factual situations. So you've got the working memory, you've got the semantic memory, and you've got the episodic long-term memory.
And we're going to go into all of those before anyone starts worrying about what they think.
Yeah, absolutely. We'll explain those in a bit more depth in a moment. But you also need to know that there are three stages to each of these systems. So you've got the encoding stage, which is the feeding of the information into the memory system. You've got the storage stage, which is preserving the information. And you've got the retrieval stage, which is taking it out of the memory for use, for giving evidence, or for putting together your witness statement. So that's the simple intro out the way. And I'm going to go to you for the slightly more complicated bit next.
Okay, let's try and break this down. Let's start with short-term memory. That's probably the easiest one. So in terms of short-term memory, you have your working memory, which is essentially that ability that we have to be able to hold certain elements of information within our brains for a short period of time and be able to then recall them. So as we are so often used to, if I want to log into something, I will need a code. I'll get the code by text message. And I could look at that code of, say, 6 digits, and I can probably remember it for long enough to go back to the website and then type those numbers in. Although nowadays phones can often just copy those over for you. But the fact that I can remember that information, or even, for example, remember an answer a witness just gave, or a sentence from a document that I'm cross-examining on, that is our short-term working memory. So it's important to identify, though, that if I still remember it tomorrow, then that's moved into the long-term memory. But if I can remember it for that short window, then that fits into the short-term working memory. So that's short-term memory. Long-term memory, Jason?
Yeah, so in the long term, as I say, you've got the two aspects to it, semantic and the episodic long term. And let's deal with semantic memory first. Now, that's where our knowledge of the world is held. And what Lord Justice Popwell explained, he explained this by putting up some random letters, I think 14 random letters on screen, and told his audience to remember those. He had put them up for like 5 seconds, took them down, see who could remember them. And everyone struggled. And then he put them up again in a slightly different order. And they now read Fantastic Judge. And obviously that made them far easier to recall. But that's because you're using your own knowledge, in that case of familiar words, not of fantastic judges, to recall the information that you need to retrieve. And as he explained, one of the things that the semantic memory system does is to encode the data by reference to your own worldview or your own experience. So through your own framework, or what psychologists call your schema. And in other words, you interpret things that you see and that you hear through your own experience, your own views, your own beliefs. And he gave the example of requiring people to look at a chessboard, which had a number of pieces on it, looking at it for a few seconds, and then it was taken away, and they had to say what pieces there were on the board and where they were being important.
Okay.
And novice chess players remembered 4 pieces. The chess masters remembered 16 pieces. And this is the interesting point, if chess can be interesting, that was only the case when the pieces were placed in positions that made sense for a game of chess. When they were put into random nonsensical positions, the novice and the expert fared the same. And that's because the experts were then deprived of the advantage of their semantic memory. And when you apply that to the employment sphere, look at an experienced manager who's regularly been involved in the type of meeting that's key to an issue in the case, that may well generally be generally better at remembering what happened at that meeting than someone who doesn't have that experience. They may be better at recalling the nuances of the meeting, and they may seem to be the more reliable witness in those circumstances. But their semantic memory also brings with it the expectation of what would happen at the meeting, which might well corrupt how they encode the memory, irrespective of what actually happened. So to give an example, imagine a badly minuted disciplinary meeting. I'm sure that we've all experienced those many a time, where there's an issue with whether the claimant was given the opportunity at the end of the meeting to say anything not already covered by the questions in the meeting. Now, if the manager knows that as a standard question, that's something that he is or she is conditioned to ask, they may well genuinely recall that opportunity being provided to that individual, even though on that occasion they didn't do so, because the semantic memory is influencing how that memory is encoded. And semantic memory can also corrupt the retrieval process as well, because a person's beliefs, their attitudes, their approaches change over time. And when witnesses are giving evidence of things that they thought or believed at the time of historic events, the semantic memory can revise the memory of those beliefs to make them consistent with present beliefs. So if I can give a recent example from my own practice, a case that I was doing a few months ago, I was against a claimant who insisted that his mentor was useless, unhelpful, and avoided offering him support. And he was convinced of this, and it was key to his reasonable adjustments claim. And his mind had magnified these flaws in his mentor. And I can say that they were magnified because when we look through the disclosure and the documents in the bundle, there were numerous emails and notes which only showed the mentor being incredibly helpful and highly and quickly responsive to any queries. And the claimant's beliefs in the depths of litigation had corrupted the retrieval of his memories about how the mentor had operated.
That's fascinating and also very common, I think, in employment cases, and many of you may have seen the same as well. Let's talk about other forms of long-term memory then. So moving on to episodic long-term memory. This essentially enables us to remember specific events or episodes, but also to distinguish them from similar episodes and events, such as, for example, one director's meeting and another director's meeting. But also, whilst it's most important memory system for witnesses, because essentially they are being asked to recall those meetings, it's actually, interestingly, the most fallible of the three kinds. And one of the reasons for that is because when you are encoding memories, you don't necessarily notice everything, because it really depends on your focus. So, for example, those of us who are old enough to remember the Krypton factor might recall this observation round, where essentially contestants were played a short piece of footage and then they had to answer questions on it. Now, everyone was watching the same piece of footage, but everyone was trying to second guess what the questions might be. And so they would remember some parts of it, but totally not notice other parts. And within Lord Justice Commonwealth's talk, he talked about a famous psychological test that we are going to try and play now to see how you will cope as well. So Sophie, our incredible marketing assistant, is going to play us a video. And I'd like you to follow the instructions, which are to count how many times the players wearing white pass the basketball. Thank you, Sophie. So the question is, how many passes did you count? Now, if those of you who are counting, you got to 15, then well done, that's the right answer. But the real question is, did you spot the gorilla? We're going to put a poll up, see how many of you did. Now, if you're looking at your screen thinking, what on earth is she talking about? Don't worry, you're not in the minority. But we are curious to see how everyone fared on this. So please do let us know whether you saw the gorilla. And whilst you're doing that, I'll tell you a funny story about this. Jason sent me this link and I watched the video. And the first time I watched it, I knew what to expect. And I wasn't focusing on counting the passes. I just wanted to see what the video showed. So I watched it and I thought, oh, that's interesting. And for those of you who did spot the gorilla, you'll say, well, that's quite obvious. And you'll see what is being referred to. Having watched it, I then called my son, who's a teenager, and said, why don't you come and watch this video? I didn't give him any context. I just said, come and watch this video and count the number of passes. And because he was sitting next to me and counting, and I thought, oh, I didn't actually do that the first time around. Let's see if I can get to the right number. So I focused on counting the passes. And even though I knew that a gorilla would be appearing on the screen, I didn't notice it. And it really drove home the point that we've just been making about how we observe things. So in terms of this poll, Sophie, can you tell us what the results are, please?
I can. 27% of our viewers said yes, they did see the gorilla, but a whopping 73% did not see a gorilla.
Well, you're not in the minority, as I said. I think when this test was done under psychological testing circumstances, it was about 50-50. So we're clearly not doing well. But I put myself in that higher percentage too, so don't worry. For those of you the majority of you who are probably still very confused about what on earth we're talking about, Sophie, can I ask you to play the next segment of the video so that those of you who didn't see it can know what on earth we are discussing? So it's pretty obvious when you're looking for it, or rather when you're not looking at something else, that in the middle of everybody passing the ball, a guy dressed as a gorilla walks into the middle of the area, beats his chest and walks up again. And just going back to why is this relevant? Why did we play this video?
Why not?
Well, I was going to say, apart from the fun factor, the point is, and I think this really showed exactly what we were discussing, which is that sometimes, because we are focusing on one thing, we don't actually notice what else is happening. And the reason that's relevant is because sometimes when we're talking about witness evidence, a witness may not have noticed or recorded, therefore, in their memory, something that did in fact happen that somebody else did see. And that doesn't mean that either of them are lying or not intending to be honest and accurate. It's simply the case that they just didn't notice or recall what happened. And so if we take a simple example of a situation where a group of employees and an individual claims that they were the victim of a harassing act or comment maybe that was made to them, it may be that others who are in that group, who are inevitably interviewed afterwards and asked, well, did you see or did you hear this issue, may not have been focusing on that or may have been distracted at that point and will not therefore have a record of that event occurring, even though it might literally have been 2 feet away from them. Now, moving on then from the video point, some other things that Lord Justice Copperwell said in respect of episodic long-term memory and some problems associated with that. He identified that there are potential issues with confirmation bias, because of course we see and hear often what we want to see and hear. There's also an issue about social conformity. So if we know what everybody else has said about what happened at a particular meeting, it may mean that our own memory is then encoded in a way that is influenced by that. So for example, if I attend a meeting and at the end, the chair of the meeting summarises the key things that were discussed or I receive an email shortly afterwards, which has a list of bullet points of the key things that were agreed or decided, that may then influence the way I encode that memory, even if it's not entirely accurate. There's also an element of wishful thinking, because encoding can be influenced by the fact that I will inevitably want to picture myself as having done the right thing. So this is the point that you were referring to earlier, or wanting to paint myself in the best possible light. So you may have, for example, a line manager who insists that they were sympathetic when an individual came and raised a concern or issue with them. And they may genuinely believe that because that's how they like to think that they would have dealt with it, even if the employee may have a different view to them. There's also the influence of loyalty or even personal ambition at this stage, because as you mentioned earlier, Jason, there is that innate desire to help the organisation that for whom
work or the link that you have to that particular issue. And that can then influence how we recall an event happening in the same way, and many of us will be familiar with this, that if I support a particular football team and I'm watching a match, I'm more likely to notice when my player is fouled by the other team than potentially the person sitting right next to me who may be supporting the other team. So going back then to Gestmin for a moment, Mr. Justice Leggett gave primacy to the accuracy of contemporaneous documents. And he said essentially, well, don't worry about what people say so much, focus on what's been done. But what Lord Justice Popplewell was saying is that although those records that are then going to be referred to as being so important and accurate may be produced at the time, very soon after the time, they're still produced after the memory has been included. And so if there's a problem with the encoding of that memory, that then affects the contemporaneous record as well. And so the difficulties or the nuances that then arise is the way that a meeting is then summarized in this email that might come out afterwards may then impact on how others see everything thereafter. And it can also affect the encoding bias of the author, because inevitably the person writing it is going to, as you said, want to see themselves in the best possible light. They're going to want to make sure that covers all the things that they expected the meeting to have covered, even though they may not necessarily have happened. And it may also be consistent with what they know is to be expected to come out of that meeting in terms of outcomes as well. So, slightly long-winded discussion about encoding, Jason. Let's move on to storage.
Before I do, I just wondered if anyone saw the gorilla walk past Safia while she was talking.
I didn't notice it.
Well, if you look at back when you view the YouTube footage, you look back in slow motion and see if you can see it then. Anyway, in terms of storage, what Lord Justice Popplewell did was to explain how our episodic long-term memory automatically and subconsciously selects the features most likely to be of future use and to discard the rest, which means that detail is more typically discarded, save for the detail which we're particularly interested in at the time of storage, or which might help our purpose at that point in time, or be the reason that we have called that meeting or have gone into that meeting, or we expected to get out of it. So just to give a very important legal example, my daughter can tell you in precise and accurate detail what flavour of ice cream she had on any given holiday that we've been on since she was 3.
That's impressive.
She can't tell you anything else about the holiday, but she can tell you what ice cream she had, and probably in order as well. Maybe coming back to employment law, it goes without saying that the aspects of a meeting which are of interest to the employee at the time of the storage of the memories may be very different to what's of interest to the manager, or indeed years later to the Employment Tribunal. And really interestingly, and I put the emphasis on the word really, the studies of that selective forgetfulness show a swift discarding of information from your memory over the very first day. And then the rate of forgetfulness slows down over time, with there being a negligible worsening of memory after 6 months. And then the curve pretty much levels off after a year and doesn't significantly change after that, even when you're talking about a 10-year delay.
Gosh.
Which means that after a certain period of time, the delay is less and less likely, as a matter of the science, to have the impact of decreasing the accuracy of recollection. And as will probably be clear to you listening to that now, and as Lord Justice Popplewell points out, just quote from him, this has relevance for those arguments about the prejudicial effect of delay which arise, for example, in adjournment or case management applications. By the time such applications arise, the prejudicial effect of further delay on recollection will usually be insignificant.
So just pausing there for a moment, I found this particular element of the talk fascinating because it pretty much turns on its head the argument that we make often about the impact of delay. But I'm going to hold that thought. Let's come back to it. Tell us what else he said about storage.
Yeah, I agree, and I think we don't want our opponents to listen to this bit of the talk. Look, when I speak to witnesses, and I'm sure it's the same for you as well, in the pre-hearing conference, I always tell them that the word that I don't remember or I don't recall are perfectly acceptable answers. I mean, if they're true. But very few witnesses ever go there. And one reason that they tend not to do so is a scientific one. People reconstruct, there's that word again, from their semantic memory, from their experience of the world, what happened. And they assume that something happened because that is what they would expect to have happened. Sometimes the answer will be put in a conditional sense, like I would have done X, or oh, I'd never have done that. But more often than not, the statement is a definitive one, with the semantic memory filling the gap with what the person would have done or thinks that they would have done. And then more so than at the encoding stage and the storage stage, false gap filling happens at the retrieval stage. And don't forget, you've got lots of different retrieval stages in a case. You've got the contemporaneous processes, such as the grievance or the disciplinary processes. You've got the instructions for the statement of case. You've got the taking of the proof of evidence, comments on the other side's evidence. You've got the questions at the pre-hearing conference. You've got cross-examination, re-examination. Now, each of those is an opportunity to reinforce an inaccurately retrieved memory. And there are also so many ways in which the memory can be deflected away from accuracy at the retrieval stage. For example, how the question is asked. A suggestive question, and we certainly ask suggestive questions all the time, can influence the outcome of the retrieval of the memory. And very interestingly, Lord Justice Popwell noted a study which showed that when participants were asked to watch a film of a car crash or a car accident and to answer questions afterwards, the speed at which those participants on average estimated the car was travelling depended on how the question was asked. So simply asking how far were the cars going when they hit each other elicited a lower average response as to the speed than how far were the cars going when they smashed into each other. And also the way the question was asked also distorted the memory of the repercussions of the car crash as well, of what they observed on the actual footage. So a third of those who were asked the question in the smashed into wording said that they had seen broken glass in the footage, even though there was none.
Gosh, so you can not see a gorilla that's in front of you, or you can see broken glass that's not there simply by virtue of the questions.
Yeah, absolutely. I mean, essentially, the retrieval of the memory there is influenced, if we're going back to the science, by the semantic memory of the expected repercussions of a crash where two cars smash into each other at speed. And Lord Justice Popwell also noted how the way the question is asked can apply to the retrieval process used in writing a contemporaneous note of a meeting. So we're talking here about deflecting the accuracy of almost immediate retrieval of the memory. And there's a difference between a neutral request for an employee to write a note of the meeting that they attended yesterday and the loaded questions such as, can you write a note of the meeting from this morning in which Mr. Jones accepted that his performance hadn't been up to scratch, or in which Mr. Jones said X or admitted to Y, or offered us Z. I'm going to run out of letters, so I'm going to stop giving examples there. But you can also have a neutrally asked question, but asked to an employee who knows what angle is expected of them in the note, or what angle's in their own interests as well.
So the final point that Lord Justice Popplewell made was about how the science of memory then applies to the process of taking witness statements, which is obviously what we're familiar with within litigation. And he identified a whole array of problems. He said, well, you've got this difficulty with what's known as the suggestibility effect. So essentially, going back to the point you were just making about the questions that are being asked by the solicitor, for example, to the individual when taking their proof and how those questions are put to them, essentially then impacts on the answers that they're going to get, which will then go into their witness statement. There may also be comments, for example. So I might then be asked to review those witness statements and I will ask questions. I might say, well, how does this fit with this document in which this was said, for example? And essentially, I'm then impacting that suggestibility to the witness, who is then being asked to answer those questions. And that leads on to a second element, which is about the act of refreshing the witness's memory with documentation, which of course we do. We'll say to a witness, well, can you review all these notes of these meetings? Some of them they may not even have been involved in or seen at the time. But the real question is, well, does it actually help the witness to recall memory of what occurred, or is it actually an exercise in filling the gaps and creating a new memory rather than actually just restoring one that was already there? And can you even tell the difference at that point? Now, there's also another element, which is, as you mentioned earlier, witnesses are asked to read or reread their witness statements, and question mark about the extent to which that then entrenches what may well be a corrupted memory with increasing certainty and confidence, regardless of whether or not it's actually true, which then might come across when the witness is being cross-examined and then can potentially impact on how the judge sees them as a witness. And then finally, you've also got this gap-filling process that you referred to a moment ago. So all sorts of issues that link together what we know about memory and what then that means for evidence in litigation.
Yeah, and this essentially brings us to Lord Justice Popplewell's two big conclusions, the first of which is a tip for lawyers, and the second is about how judges should approach questions of credibility and fact-finding in respect of historic events. So the tip that he gives, might be obvious now, is what this means for the advocate is that in cross-examination and submissions, the angle of attack in respect of most witnesses is more likely to be successful if it seeks to undermine the evidence by reference to the various sources of innocent memory error, rather than a blunt and simplistic attack on truthfulness, which is probably what I've done for the last 20 years.
We're going to have to rethink
Yeah,
that.
absolutely, absolutely. And you can really see how a judge is more likely to be receptive to the suggestion that a person has wrongly remembered something, with an explanation of why, in the context, that might have happened, as against the far more blunt suggestion that just because the witness's evidence is inconsistent with that of your own side's witnesses, he must be lying, he or she must be lying. There's a natural reluctance to find someone to have intentionally lied, unless you're absolutely sure, unless it's my children. The second conclusion, the one for judges, is the one that was put softly at the start of the speech. Some disagreement with Mr. Justice Leggett's proposition that little, if any, reliance should be placed on a witness's recollection, and that one can feel safer placing reliance on the documentary evidence and on probable facts. Now, we dealt quite a lot with how Popplewell raises concerns about the accuracy of documentary evidence. I can deal much more quickly with probable facts. He says, in essence, first, that determining what's inherently probable is a subjective exercise about how people would usually behave in given circumstances, and the soundness of a judge undertaking that subjective exercise with their own beliefs, their own semantic memory, essentially, their own understanding of the world and understanding of the circumstances of those individuals is itself questionable. And secondly, that just because something is probable doesn't mean it happened. We've all been in situations where the improbable was what actually occurred. So those are his two conclusions.
So we want to go on to look at how those principles could then be applied to employment cases. And we're going to do that in a moment. But just before we do, it's also interesting to see how his speech has been used since. Been picked up in a few cases, none of them employment cases, at least not yet, although as we say, that may well change and we're hoping that it will. But there's one really interesting case that we just want to touch on very briefly because the principles from it are just as applicable in employment cases, where the principles from Lord Justice Popplewell's speech were applied. Case is called Jaffe and Grable Capital. Again, the link is in the chat box and we'll send it out as well. And essentially, again, in very simple terms, it was a fraudulent misrepresentation case. Question was about the source of funds which were injected into Monarch Airlines, for those of us who remember flying on that when we were kids, and whether there had been oral misrepresentations at an important meeting about the identity of the source of those funds. Now, there was, again, a gap of 8 years between the meeting and trial. And the key issue to be decided was whether at the meeting, the issue of the source of the capital had been raised and what answer had been given to that question. Now, there were a number of attendees at the meeting. They were all called to give evidence as witnesses. One of them, from the claimant side, had also made some notes at the meeting. They then held a short discussion with a colleague immediately after and then started to write up a note and completed it the next day. And in that note, they said, was a reference at the meeting to Boeing not contributing capital to Monarch or providing capital to Grable. Now, if this was said, it was untrue and it was the basis of the misrepresentation claim. Now, in the judgment, the judge dealt with a number of issues that arose in the Popplewell speech, dealing with the corruption of memory and the potential impact on the objective accuracy of contemporaneous documents. Because if we go back to the principles we started with in Gestmin, the argument was and would have been, well, this was a note that was made at or immediately after the meeting. It clearly says, if it is accepted, that there was what we now know to be a misrepresentation, and that should be given primacy. But there were some really interesting factual findings in this case that then led ultimately to the conclusion. First of all, the witness who had made the note of the meeting, a Mr. Hills, was described by the judge as an excellent witness and I quote, particularly careful and meticulous, as well as the antithesis of a partisan witness. That's a good place to start.
That's a very good place to be.
Of course. One of the witnesses on the defendant's side, a Mr. Bennett, said that let me get that right, said that another colleague who was accused of making the false representation lied in the meeting. And had he done so, I should say, that Mr. Bennett would have remembered it. So essentially he was saying, well, look, if that had been said, I think I would have remembered it because I knew it wasn't true. And he also said, well, not only would I have remembered it, I would have felt really uncomfortable about it, given that I knew it wasn't accurate. Now, the claimant's side said, well, in light of the principles that Popplewell referred to on memory, that wasn't how memory worked. And because Mr. Bennett saw himself as a man of integrity, that he wouldn't have wanted to consider a situation where something may have been said that was untrue and he hadn't done anything about it or said anything, he was unlikely, therefore, to have encoded a memory, stored it, and then retrieved it in a manner that potentially put him in a situation where he'd sat through somebody lying and hadn't done anything about it. Now, the judge noted that the claimant's side essentially said that the judge needed to rely on the note of the meeting, so the Gestmin principle again. And they said that given that the writer was, as the judge had recorded, an honest witness, it was near to contemporaneous
in terms of when it was made. And given that, interestingly also, the other side accepted that in every other respect, the note was accurate, they said, well, that's the key point in this case. But the judge then pointed out the possibility of a faulty recollection being encoded at a very early stage, so right at the very beginning, and then recorded in the note. And therefore, she said, she needed to test its contents against the wider context of the meeting. And that's actually the really key issue in terms of this new approach to looking at contemporaneous records and witness evidence. And so what she did was to consider these concerns about the fallibility of contemporaneous documents and consider that to be more important than this Gestmin argument of saying, well, documents are king. And her questions on the context of the recording of this note were addressed in part to issues that could impact on the accuracy of the memory at each of those three stages. So that encoding, storage, and the retrieval. So she looked at questions such as, well, what were the parties looking to get from the meeting? And that's a key question on the possibility of encoding infallibility and the drafting of a near contemporaneous document, Jason, as you said earlier. Because if you know what you're trying to achieve from the meeting, you're more likely to remember that part of it. And so in this judgment, the judge noted that in the context of looking at that scenario, the investors had a pre-prepared script for this meeting. And the judge's view was it was unlikely that the speaker would go off message on this issue because they pretty much expected that it was going to come up. And there was nothing to gain for him to lie in the way suggested by the claimants. And notably, whilst Mr. Hiltz's note had said that the speaker had said that Boeing did not contribute capital to Monarch or to Grable, the script said that Boeing hadn't provided equity or loans to Monarch. Now, for those of us who aren't involved in commercial cases, the distinction might not be that significant. But in this context, it was huge in terms of whether or not that was a true representation or a false one. So that was the key point. What else did the judge say, Jason?
Well, it's fascinating, given the confidence that the judge gave to Mr. Hiltz, and as you say, he seems to be the perfect witness, and I don't think the judge would demur from that conclusion about him. But she actually ultimately concluded that his record was inaccurate, albeit innocently inaccurate. And she noted that it was a reconstruction in his second language. I think it was German, is that right?
I think so, yeah.
From incomplete handwritten notes made at the meeting. And it was a reconstruction following a lengthy meeting. And that there was scope for Chinese whispers in the taking, as she wrote it, in the taking of a note and its interpretation, especially when there was discussion immediately afterwards with colleagues before writing the finalized note. And the judge relied on Justice Popper's lecture for the fall off of memory between a meeting and the writing up of a note the same day or the next day.
So that's the short term, long term.
Yeah, absolutely. And she also held that it was likely also that Mr. Hiltz had got Wirecard's agenda encoded in his mind, and that he thereby interpreted what was said in a slightly but significantly different way from what was actually said. So we're looking again for what, are we looking for the passes or are we looking for the gorilla? So that in recording his recollections, the small but significant deviation from accuracy then became entrenched throughout the litigation process. So that's the lesson from Jaffe. Don't just give primacy to contemporaneous documents, ask questions about context of the production that interrogate the impact that the fallibilities and the prejudices of the encoding of memory might have on its accuracy. I just want to briefly, looking at the time, mention another more recent case where the lecture was considered, and that's the case of Macon and the Restaurant News which again is in the chat box, and it's also going to be on the the link that we send out to you by email. Now that's the case where Mr. Macon went into a restaurant. He got rather drunk. He threw a glass to the floor. He was ejected by the restaurant's door staff. I don't know if you've ever been to a restaurant where there are bouncers on the door. I don't think I have. Anyway, he had an altercation, which ended up with him being in a headlock on the ground outside the restaurant. He took a taxi home, and a couple of days later, he was found by his mother to have suffered from a stroke. Now, it was more than 2 years between that incident happening and the notification of the claim. And the judge noted from the Popplewell lecture that the impact of the delay, but noted in particular that the drop-off from memory was greatest in the first 6 months. Remember how the curve went after the event, and there's a delay between 2018, 1 year afterwards, and 2020, which was 3 years later, would not have been likely to have resulted in any further greater diminution of memory.
Interesting. So, conscious of the time, what we want to leave you with are really just a couple of points as to where we think this leaves us in the employment context. And there were a number of things that we thought about as we were preparing that we wanted to share. So first of all, so many tribunal cases, as we know, turn on what was said in a conversation or at a meeting, or often, and sometimes more importantly, how it was said. So tone, style, that sort of thing. And what the principles in the Popplewell lecture really do is to provide us with some feed for thought about how do we go about challenging the evidence of an account that is in conflict with our client's position, that might go beyond the classic, well, you're just mistaken, but without having to resort to the you're lying point. But think back to that gorilla for a moment in that video, and keep referring to this, I know, because for a small number of you, it was blindingly obvious that there was a gorilla in front of you, yet for many of you, it's something you missed entirely. So the question, I suppose, is how can we then utilize that to deal with a situation where there is a difference of recollection between two parties, maybe as to the purpose of the conversation, how it came about, what was said, who else was doing what at that time. How can we use that to our advantage? I think the other interesting thing that comes out of it is about the process of preparing for litigation. And we talked about how evidence is taken and how that can affect the recollection of events. And it may be that that can also be utilised in terms of how we then make that argument that one party may not be giving an entirely accurate account of what occurred.
Yeah, and there may or may not be minutes or notes of that conversation, but the lesson is don't assume that the contemporaneous note is entirely accurate. Examine who wrote it, when, for what purpose, on whose instructions, how it came to be written. And like in the Jaffe case, what surrounding circumstances can you use to highlight that the other side's note may not be an accurate or full account of what occurred?
Now, let's come back to that point that I raised earlier about dealing with time limit issues, for example, in terms of how memory is affected or potentially affected by the passage of time. And I think the key principles that shone out to me from this were, if I'm the one who's trying to say, if I'm not part of a respondent, well, actually, the longer the time has passed, the more prejudice or the greater the prejudice to the respondent, I may struggle with that argument. Or equally, if I'm on the other side, I may want to be making the exact opposite argument based on that curve that you were referring to a moment ago as to how memory works. And so if you are on the respondent side, it may be that you will need to think about other forms of prejudice, whether or not documents have been retained, for example, availability of witnesses, because simply saying, well, it's been so long ago, you can't expect people to remember, may not be enough anymore.
Yeah, I think that's right. Now, just on practicalities, if the claim is a particularly high value, and it really does turn on recollections of conversations or meetings, it might be the case that one party wishes to obtain expert evidence on memory and how memory can be impacted. It's not something we've seen in the Employment Tribunal yet, as far as we're aware, anyway, but maybe something to consider in the right case.
Correct. And I think the final point that we wanted to leave you with is thinking about the impact of all the issues we've discussed on memory at different stages of proceedings. So it may be that it's something that you need to be thinking about from the outset, particularly when you're putting together merits assessments, for example, when you know there is a very significant dispute between the parties about a particular point, because simply saying, well, there's a dispute, I'm not really sure where it's going to go, or saying, well, it looks like there are some documents that might be supportive of one side or the other, may not of itself be enough. And I suppose the bottom line is, it may be that you don't want to be too bullish about your position if you're the one who has the documents that help you, but equally you may not want to disregard the other side's position, even if actually the contemporaneous documents don't completely help their case. I think the other thing in terms of practical applicability of this is looking at particularly things like applications. So we've talked about time limit issues, amendment applications, similar principles, strikeout applications, again, some of those same arguments in terms of there's a fair trial possible, equally are just as relevant when it comes to looking at these things. Now, obviously, some of the key areas I think are likely to be cross-examination at final hearings, submissions, but it's also important to remember that these are issues that you may want to be reflecting on from an earlier stage, particularly in cases where there is such a significant dispute about what happened or why, etc.
Right. I think, unless I've forgotten anything. Question. Do we have any questions?
I don't think we have time, I'm afraid. We've run over, so we do apologise for that.
Fine. We'll email you if there are questions. Then we can email you answers to those afterwards. Well, thanks very much for coming along and watching our session. We hope that you've enjoyed our discussion about how memory works and how that information is relevant to employment tribunal claims. There's a lot to take in, and you'll all doubtless remember parts incorrectly from tomorrow, as we now know from the curve. So feel free to watch the recording on YouTube multiple times and bring up our figures and make us employment influencers, or whatever the term is.
Or look for the gorilla.
Well, I was going to say, make sure that after this you go to your family and your friends and ask them to count how many passes.
Oh, we'll send the link out actually for the YouTube video in our email as well, for those of you who want to try it out on family and friends.
No, that sounds like a good plan. Now, as we said at the beginning, we'll be sending out an email with the links to the cases we've referred to. We'll send out the Popwell lecture as well for those who want to read it in full, and I would highly recommend it. It's a very readable thing anyway. It is genuinely enjoyable, and I don't always say that about judicial lectures. And we'll send a link to the recording, and also crucially, we'll send the feedback form. Please do let us know if you found this session to be useful, because that's useful feedback, or if you found it not to be useful, because either way it's useful feedback to us. Now, if you've not put a question, we've got the questions in the question and answer box recorded, and we'll respond to those. If you haven't put a question there and there's something that you want to ask, please do send us an email. Or if you're watching this on the recording, they always say about telephone numbers, don't they? Like prizes on the recordings. And you've got a question, again, don't hesitate to email us and we'll get back to you on it. Thanks very much for joining us. We look forward to welcoming you to future webinars and to the annual lecture in September. I think that's probably what we say. Don't forget us, and goodbye.
Good evening.